Good morning and welcome to the First District Court of Appeals. We have one case that will be argued this morning. It's Guthrie v. Guthrie. If the attorneys could please come up. If you could please identify yourselves, who you're representing, and your readiness to proceed, please.
Yes, Your Honor. My name is Leslie Thomas. I represent the appellant. This is Jill Guthrie.
Thank you.
Good morning, Tracy Hill, representing Applebee's, Jean Guthrie, and Regina Lindholm.
Thank you. Okay, thank you. Ms. Thomas, whenever you're ready, you can come up. Would you like to reserve any time?
Yes, Your Honor.
How much?
5 minutes.
Okay. And I will be keeping time, which is on the podium. Green means go. Yellow means you have about a minute, and red means that your time has expired.
How long is my argument, Your Honor?
15 minutes. So 10 and 5 if you choose to reserve.
Good morning, Your Honors. May I please support? My name is Leslie Thomas. I represent the appellant, Mrs. Jill Guthrie, in this case of Guthrie versus Guthrie. This case initiated in the Hamilton County Probate Court. And I would like to say, as a way of background, one of the two key considerations in this case are two powers of attorney. The first power of attorney was initiated by Mrs. Jean Guthrie, who is an incompetent, she was never declared incompetent.
Ms. Thomas, before you get into the details of this, I guess there's a threshold question that's raised by the appellee here, which is that I believe you didn't order transcripts from what happened before the magistrate, and then your appellate brief does not cite to the record at all, which is required under our rules and the Ohio appellate rules. So, how can we evaluate your case if we don't have citations to tell us where the relevant materials are in the record and without the transcript?
I guess that's an issue for me, Your Honor, but I would also say that one of the considerations that we had is that the judge in his order, in his decision, when he reviewed the magistrate's decision, he essentially basically recited what the magistrate had cited, and we believe that he did not do an independent review of the whole matter. And so since there's no findings of law or findings of fact and conclusions of law.
Let me make sure I understand what you're saying. When the trial judge reviewed your objection, there was no transcript of proceedings in front of the trial judge?
No, I'm saying, Your Honor, that the judge simply said that he reviewed in his decision, his written decision, he reviewed the magistrate's decision.
Right.
And that
But let me, and I don't mean, I just want to make sure that I understand. I understand what you're saying, but I want to make sure that I understand something clearly, okay? There's no transcript proceedings in front of us from the magistrate? Is that what the deficiency is?
That's
I was told that the court was going to file the transcript of the proceedings. So,
But was it filed before the probate judge reviewed?
yes. Well, he listened to
And
the
that's
tapes.
that's the crust of my question,
Okay.
is the magistrate does their decision, there's a hearing.
Right.
And there should be a transcript with regard to that. The objections are filed,
Right.
right? When the objections were in front of the trial judge, was also the transcript from the magistrate, from the hearings before the magistrate, before the trial judge, in reviewing and deciding the objection?
I believe
And
that.
if you say you don't, and the answer could be, I don't know, okay?
Okay.
Right.
Well, from what I was told, the judge listened to the tapes of the proceedings. At the time that we went up on objections, my client did not have the funds to prepare a transcript. We presented that to the judge. He has listened to the tapes, which I've been practicing that court for a long time. That's not an uncommon procedure for him to listen to the tapes. So there was no written transcript, to my knowledge, at the time that the judge reviewed it, but that subsequently a transcript was prepared and produced.
because I know that you're really here to argue, like the merits of this,
Right.
right? Do you know if the record reflects that the trial judge listened to the tapes in determining their decision on the objections?
I don't actually know, because what I read in the judge's decision,
Well, the trial judge's decision says that he did that.
okay,
And I guess going back to where you started on saying the trial judge did not independently review the evidence, I mean, the judge saying that he reviewed the audio recordings, like,
Right.
doesn't that sound like independent review? I mean, we expect the judge to either read the transcript or do what the judge did here, which
Sure.
is listen to that. I mean, to me, that sounds like independent review.
he listened to the tapes, but what he did not do in his decision or his judgment is tell us he didn't list the facts, and he didn't list his conclusions of law. The only thing he stated in here was that he was basically concurring with what the magistrate had done, and we did not. There were some specific issues that we felt that, that's the reason why I guess we're here today, that we felt that still needed some additional review.
Do you have any evidence that he didn't review independently?
Oh, no, you
I mean-
I can't begin to, I'm sorry, I don't know. I don't know.
Is a trial court required to separately set out a review of the facts and conclusions of law?
Are they actually required? I think that was an expectation, but I'm not really sure if it's an actual requirement.
Okay, thank you.
But he also, looking back at the judge's order, the judge said that he did conduct an independent review. So, like, what are we supposed to do with that? You're saying he didn't conduct an independent review. Here we have the judge in writing saying, I did conduct an independent review. And that review could be right or it could be wrong, but, like, I just don't see any indicia in this entry that he didn't do what he was supposed to do.
Okay, that's certainly your interpretation, Your Honor, I guess. We were kind of expecting a little bit more in the way of a statement on whether our arguments were flawed or were accepted. So my interpretation is different from yours. That's all I can say. So, going back to my argument, there's two powers of attorney here. One was made in 2013 by Mrs. Jean Guthrie. At that time, she designated, it was a springing, durable power of attorney. She designated her daughter, Jill Guthrie, to be the attorney-in-fact. Of course, her powers were invoked at the time when, according to the terms of the power of attorney, there were two independent doctors who specialized in the field necessary to review her specific disability, to say that she was mentally incompetent. And in fact, in 2016, we had such an analysis from two doctors, two geriatric specialists in Cincinnati that made that determination. So at that point, the Jill Guthrie's powers under the 2013 power of attorney were invoked. And then the second power of attorney that's of interest in this case comes in 2021. And in 2021, let me also say that the original power of attorney required that if Mrs. Jill Guthrie was ever restored to competency, she would have to go through the same process of having two independent specialists make a determination that she's been restored to competency. So we fast forward to 2021, where Mrs. Guthrie is in a nursing facility. She has people who are rendering assistance to her. They, in turn, essentially prepare a revocation of the power of attorney that was initiated in 2013. And then a week later or a month later, they initiated the second power of attorney. Now, the revocation of the power of attorney never acknowledged the fact that Mrs. Guthrie was supposed to be restored to competency, by having an analysis from 2 independent doctors. That was all ignored. My client, working under the terms and the agreements of the 2013 power of attorney, is continuing to proceed to make payments and on behalf of her mother. Now, one of the authorities that was rendered or given to her as power of attorney, or attorney-in-fact in the 2013 power of attorney, was that she would be able to hire accountants and attorneys and other agents who would be able to provide services for the best interest of the ward. And of course, we know that she has a fiduciary duty to act in good faith, to act in the best interest of the ward, to protect the ward's estate. We know all of that. There was also the power to make gifts under the 2013 power of attorney. So my client, not a very sophisticated person, but she's operating under the 2013 power of attorney from all the way up to 2021, 22, and then at some point she's aware that this new power of attorney existed, but she didn't acknowledge it because she recognized that it did not follow the initial terms.
Ms. Thomas, if you care to reserve 5 minutes, your time has expired.
Okay, all right, thank you. Am I done now?
That's been 10 minutes, so you'll have 5 minutes on
Oh,
rebuttal.
Okay, all right, thank you.
Ms. Hill?
Good morning, Your Honors. May it please the court. The threshold issue, as Your Honor discussed earlier, is whether or not the transcript was filed according to Civil Rule 53, D3B3, and that simply did not happen. The trial court did not have the luxury of reviewing the transcript of the proceedings.
But what's wrong with what the trial court did here, which is reviewing the audio recordings, which to me seems like a reasonable way to deal with people who may not be able to afford the transcripts, and at least to give them, their day in court by reviewing that. I mean, the trial court could also hear evidence anew if he so desired. So I guess what's wrong with just listening to the audio recordings?
I don't disagree. I believe that the trial court, within its discretion, did have some authority to review the audio transcript. In fact, in preparing for the hearing, we did come across a case, T-Walt versus Peacock out of the 3rd District, which is almost on all fours with the facts here, except the court there, sua sponte, decided to review a video recording. So I don't believe that there was anything improper. It's just that the court had to do a little bit more heavy lifting in this case and did not have the benefit of the black and white written transcript in front of it. And so while the court can consider, we believe, alternative technology, I don't believe that in this case it necessarily was as appellant states, because they had filed an affidavit of indigency, and there wouldn't have been a cost for the transcript in this case. But yes, the court did review the transcript. The court also reviewed the file. The court stated it reviewed the written submissions, which would include the accounting, because that's why we're here on summary judgment on plaintiff's counterclaims for all of the breach of fiduciary claims that were asserted against the appellant. Because of her acts as power of attorney, she was more than just her mother's daughter. She was also a fiduciary to her mother. So yes, the court made an independent review here, while it did have to go kind of outside of the norm to listen to the audio recordings. There's no
For the
indication.
objections,
What's
so,
that?
yeah, for the objections, I understand what you're saying. So, quick question, to your understanding, the trial court's decision, sua sponte, to review the audio recordings, does that relieve the appellant from the requirement to provide transcripts in front of the Court of Appeals?
I think it's a great question. I believe it does not, because Civil Rule 53D has 2 separate sections. There's D3, which are the requirements of the objecting party. Then there's D4, which is the requirement of the court to rule upon the objections. So if you look at Civil Rule 53D3B4, it states pretty clearly that the objecting party cannot assign as error on appeal the fact that the trial court adopted the magistrate's findings of fact if you don't comply with the other parts of D3, which includes D3B3, which is the filing of the transcript. So hopefully that answers your question.
Right.
I believe they're two separate obligations.
So let me ask you another question, right? I think you would agree that any error assigned or issues under error assigned with regard to factual determinations made by the trial court, we would have to presume the regularity
Yes.
based on the lack of the transcript, right? Are there any, now, when it comes to issues of law, that's different, right? Are there any issues of law that are being argued by the appellant?
I don't see any. I think that primarily what appellant is objecting to are these the adoption of the findings of fact. A lot of the findings of fact originated 3 years ago in the guardianship proceedings, and there was a magistrate's decision there.
One thing I've always been perplexed about is, like, why are there findings of fact if there's a grant of summary judgment? I mean, those two seem incongruous.
And maybe I'm not understanding your
Well,
question.
I believe that the trial court, the probate court says it enters judgment in granting the motion for summary judgment. So summary judgment we think of as there's no factual findings because we take the facts in favor of the non-moving party and we apply those to the law. So, like, why would the magistrate have been making factual findings if they're granting summary judgment?
I think here, in this particular instance, because we're dealing with facts that have already been established or adjudicated from the guardianship, both parties did present on cross motions their different versions and their different facts in support of their motions. And so, in this case, I believe it's just the way that the probate court works. A lot of the decisions that arise from probate court are in this format. And so what the magistrate did, as I recall, she set forth each party's version, and then she decided which version was supported by the actual evidence in the record.
And that's the guardianship.
That's not
Action.
only in the guardianship, but also in the civil case as well.
Okay.
So in the guardianship, there wasn't, because it's non-adversarial, there wasn't that back and forth, but the court, in its decision of having to determine competency and having to determine who is suitable to serve, still made those same findings of fact. And so throughout those proceedings in the guardianship, there were things that were uncovered, just like the appellant's misuse of the power of attorney, several thousands of dollars missing from her mother's accounts, all claimed to have been made in her mother's best interests. But when you look at the record, when you look at the accounting that is attached to our objections to their accounting that they filed, you can see, if you look at the accounting, I mean, they're just blanks. There is $1,000 spent on something, right? And the guardian ad litem obviously saw that too and said that she would not recommend appellant to serve as the guardian of her mother because of those things. So I think that just hopefully I answered your question, Your Honor, with respect to the findings of fact. But those
Here's my question on the findings of fact, and I'll
Yes.
have to kind of fine tooth this through. Do you know if any of these findings of fact were facts that were being contested? Or
The
were they
findings-
uncontested?
The findings of fact actually, in terms of officially contested, I
In other
think
words, was one side saying A and the other side was saying not A or B or whatever?
there is a lot of that going on because if you look at the magistrate's decision from the guardianship, The court clearly says, for example, I think there's footnote 25 on page 7, where the now appellant did not come to court to provide evidence.
Yes, there's no verification of this allegation was provided to the court.
Right. But in this civil case that appellant filed, she states that everything that I did was for my mother's benefit. The attorney's fees that were paid was already litigated in the guardianship. And you have the court in the guardianship saying, you never showed us what you spent the money on. You never brought the
So
evidence.
basically, assertions were being made that could be viewed as self-serving.
That's what the magistrate
But there weren't
determined.
anything substantive or anything supportive of that.
No, and that's what the magistrate determined at the hearing, is that she could not accept the self-serving statements of appellant
Okay.
because there was no evidence substantiating the fairness of any of the transactions.
Yeah, because again, I'm trying to figure out if it's a summary judgment, how the findings of fact. Now, if it was uncontested or was supported only by self-serving statements, then I could see my way there.
Yes, yes,
Okay.
yes, Your Honor.
Thank you.
Thank you. So our contention is that not only are there procedural deficiencies with this appeal, as Your Honor has mentioned before, about the failure to cite anywhere in the record any evidence to support these assignments of error, even substantively, when you have the trial court essentially listening to the hearing in which no evidence was presented, there really isn't any other conclusion for the trial court to make. In this instance, when the appellant came to the hearing with no evidence to support the same rehash, I did it for my mother's benefit. I went to Domino's Pizza for my mother's benefit. I spent money at classmates.com for my mother's benefits.
How would
It just
she,
doesn't
you know,
pass the
but
smell test.
As a practical matter, how would she present supportive evidence beyond her saying, this is why, you know, my mother wanted some pizza, and I went and got a pizza for us to share together or whatever, you know, like, how would she support that?
So under 1337-34, one of the duties is the duty to keep records. And so what the court found in this instance is that there were no records. And so if you look at the accounting, what happened is that the appellant used the debit card to the mother's accounts pretty much as her own personal fund to fund everything that she wanted to do, but nothing for her mother's benefit. And so going back, she would have either receipts or, you know, some evidence of transactions. I think there was testimony with respect to insurance, burial plots, but none of the underlying documentation was there. Even with respect to the assertion that $19,000 was spent on attorney's fees, well, that may be for appellant's fees, but why should those fees come out of the proposed wards fund?
Can I ask you another question? Because I'm getting questions as this goes on. So at this hearing for summary judgment, was there testimony taken? Is that what I'm understanding? Or was it arguments that were presented?
There were two hearings. The first hearing was in June of '23, and that was on summary judgment. And then the court issued partial summary judgment in our favor, in our client's favor, and held in abeyance the determination on the adjudication on the counterclaims. And so the hearing in January of this year was for appellant to come prepared with evidence showing how the money was spent. So the court held it
It's
abeyance.
essentially a damages hearing?
Essentially a damages hearing, absolutely, yes.
But the first hearing, were there arguments presented or was there testimony presented? Or both?
At the first hearing, there was testimony presented,
See, and this what makes it confusing to
And
me, because in a
yes.
summary judgment, you don't take in testimony.
and we objected to that.
Okay.
We objected to
I mean, it
that.
seems as if it got morphed into a hearing on the merits,
Yes,
which is very interesting, because I'm not sure that it gave appellants the ample opportunity to prepare if it's a, hearing on summary judgment is very different than a hearing on the merits.
Yes. So the hearing on summary judgment, appellant brought an expert witness to testify as to our client's mental capacity.
Okay?
And so that was something that appellants wanted. We were caught a little bit off guard and by surprise,
Okay.
but that is what happened. Yes, testimony was taken. To answer your question, testimony was taken at the summary
Okay.
judgment hearing.
But it was with an expert,
It was with a medical expert as to capacity.
so it wasn't with regard to the daughter who had held the power of attorney.
No, the daughter did not. She spoke at times during the hearing, but I don't believe she was sworn in under oath.
Okay. In your opinion, do you believe that the trial court weighed credibility at the summary, as a conclusion of the summary judgment and found the daughter not to be credible, or didn't give any weight to the daughter's testimony or something like that?
I don't know that that's necessarily reflected in the court's entry. Certainly, the magistrate felt so.
I'm sorry, I should say the magistrate.
Yeah,
yes,
I
yes.
think that the magistrate did, because the magistrate had had the case for all intents and purposes for 3 years.
Okay.
And so there was extensive testimony over 4 days in the guardianship back in 2021.
Okay.
And so there were quite a few evidences of,
And the guardianship was not a summary judgment, or was that?
no, it was
That was-
not. It
that was
just
on the
a
merits.
It was just on the merits, on the determination of whether or not the mother, our client Jean Guthrie,
Right.
was competent, and whether her daughter Jill was competent or suitable to serve as her guardian.
Understood. Okay, thank you so much.
Okay, I'm glad. Thank
Thank
you.
you.
Ms. Hill, your time has expired unless there are other questions from the panel.
Thank you.
Okay, thank you. Ms. Thomas, you have 5 minutes.
I would like to say that the appellant did not have adequate opportunity to testify on the expenditures. The last hearing that we had, it was more in the form of oral arguments and a presentation of the accounting. The magistrate asked some
I think
questions.
the heart of like what I'm questioning now is, in front of the magistrate, there's a summary judgment, and whether the magistrate in essence weighed evidence, which would be improper in a summary judgment, you know? You understand what I'm saying?
Yes.
Which also goes to, weigh the evidence. If summary judgment is arguments is not necessarily for determination on
Right.
evidence and things of that matter, and so goes to like, did you have an adequate opportunity?
Yeah, I would just say that I don't think the appellant had adequate opportunity to give testimony and to provide evidence. We presented the accounting.
Well, but I guess, did you ask for that from the trial court? Did you object and say, hey, I want to testify, like, it's my turn to testify?
Right. Well, no, we did not. We did not ask for that. But what I will say is the accounting that we provided is consistent with the accountings that probate court requires. We had bank statements. There were no canceled checks, and she didn't write any checks. So it was all electronic funds transfers, which is itemized in each monthly statement. And that's where, as counsel refers to, there were several transactions that occurred in local retailers.
Well, would you have had the opportunity, because I don't know that you can read the magistrate's mind and foresee that there would be a weighing of the evidence.
Right, I understand that,
Understand
Your
what
Honor.
I'm
but-
saying?
Yes, I do.
Yeah,
But we
yeah.
did also
Like
say to...
like objection, you're going to weigh the evidence, even though you haven't written your decision yet.
Right.
I
No,
don't think it would work that way.
We didn't raise that objection, but we did state to the magistrate, and this is, as counsel has stated, that these two cases are married. There's the guardianship case, which had happened, as counsel said, in 2021. Lots of testimony, lots of the basis for the financial issues that came out in the guardianship case, and subsequently, there's a civil case. And so the civil
Before
case...
you go on, I have a question about the guardianship case.
Yes,
Was- After the judgment came out in that case?
Yes.
Was there an appeal?
No.
Okay, so that, the findings of fact and the conclusions of law
Right.
are considered part of this case now. So it's, those are settled.
Yes.
Okay, so those conclusions from that case are settled. Those
Yes,
are the
Your Honor.
facts.
Yes, they
Okay,
are.
thank you.
But part of what came out is that there were expenditures by the appellant for the benefit of her mother. Now, part of these expenditures, and I was there, we were there, it was for 4 or 5 days, a lot of transactions for attorney's fees for the guardianship case. This guardianship case lasted almost a whole year. So it was $11,000 in attorney's fees, and that these attorney's fees were not denied, nor did the court find that those attorney's fees were inappropriate or out of range or distorted relative to the services that were rendered. So those, when we had the final hearing for the magistrate, when we presented the accounting, we said $11,000 of this $36,000 that the magistrate found that was inappropriately spent by the appellant was $11,000. That 1/3 of it was for attorney's fees, and that
Do you
was.
have any authority, any case law, anything showing that it would be proper for your client to use to use her mother's funds to pay for a guardianship case that your client initiated?
The only thing that we relied on, Your Honor, was that 2013 power of attorney was not, at the time that those attorney's fees were paid, there was no clear indication that there's another power of attorney. She's, as I started out by saying, she's operating under that power of attorney for all these years.
But even if that power of attorney, let's just say the power of attorney was still in place, was valid.
Right.
She would still, the fiduciary would still have to expend the money in her mother's best interest.
Correct.
Because she's not just the daughter, she, at that point, is the fiduciary.
I understand.
So is there any authority that you have showing that it would be proper for her to use her mother's funds to pay for attorney's fees for that case?
I'm going to refer to, I think it's 1336, ORC 1337.34, where basically a fiduciary it outlines the responsibilities of a fiduciary. A fiduciary has a responsibility to act in good faith and for the best interest of the ward or the person who needs protection. So pursuant to that, she initiated the guardianship case because she thought she was acting in her mother's best interest. And so that's the authority that I refer to.
Okay, thank you. And unless the panel has any further questions, your time has expired.
Thank you.
Okay, thank you very much. This case has now been submitted, and we will issue a timely decision. And that is all the cases that we have for today.